Ready, start. We shall now proceed to deal with the submissions canvassed on behalf of the respondent numbers 4 and 5, that is the first school and the second school. At the outset, we clarify that the legislature, in its endeavor to enforce fundamental rights for the transgender community, has placed an obligation to uphold the rights of the community on both the state as well as private parties in the 2019 Act and the 2020 rules. Some of these rights are couched in a negative language, thereby enjoining upon the state and private parties to not act in an exclusionary manner, whereas others are framed in the nature of a positive duty of the state and private parties to ensure that the community is brought into the mainstream. Pertinently, Section 10 of the Act is very clear in its words that all establishments, including non-state establishments, as per Section 2 within bracket B, have a responsibility to accommodate transgender persons by providing them with the statutorily prescribed facilities. Section 11 further ensures that if such establishment fails to stand by the mandate of any provision of the Act, including Section 10 read with Section 3, a complaint officer shall be in place to deal with such complaints of non-compliance. Having perused the legislative framework, we now come to the facts of this particular case. In the present case, a lot of allegations and counter allegations have been leveled. According to the petitioner, she was terminated from service on the ground of her single inverted comma gender identity single inverted comma close included in the ground of single inverted comma sex single inverted comma close mentioned in Article 15. However, the first school contends that the reason for her dismissal was the fact that she had been irregular and was not standing up to the tasks which were allotted to her. The submissions canvassed on behalf of the petitioner indicate that her termination from the first school was a result of the discriminatory attitude and non accommodation by the latter. It is her case that she was forced to resign as the school was not open to employing an openly transgender person. The first school has stated that the school administration was made aware of the petitioner's gender identity upon her joining, and she was accordingly placed in a women's hostel and provided access to female washroom. A bare perusal of the communications attached by the parties in their writ petition and affidavits indicates that the first school accommodated the petitioner's requests from the beginning and attempted to make her stay and school environment as conducive for her as possible. Though we admonish the school administration for turning a blind eye to the body shaming of the petitioner and problematic conduct by one teacher, yet we are of the considered view that the school did not actively or intentionally support or commit discrimination. The first school also acceded to the petitioner's requests for rehiring subject to an assessment test. The documents placed on the record show that there were several emails exchanged between the school and the petitioner in this regard.